specific statutes. And so one of the things that happened in 2004 is any land grant that's recognized as a corporate body, under the new revised laws, they have the option, if they want to actually go back and ask the legislature to recognize them as a unit of government and kind of repeal their corporate statute, and they become a unit of government. You guys are a little bit different and unique. I was looking at, I had an opportunity to review your guys' incorporation paperwork, and it's actually set up more like a business with shares. And we have had other land grants that have had that in their history. Eco Land Grant was one. We have the ABQ Land Grant that was set up as a livestock cooperative, and we still manage 16,000 acres of land. And what some of those communities have chose to do is they've actually opted to go back to becoming a unit of government. And so that would mean basically taking the assets that are owned by the corporation and transferring them to the new entity, which would be a governing body. And then they would be required to follow the statutes in terms of elections, in terms of reporting. There are some benefits and some drawbacks to that. Benefits being that you, as a community, you would now be eligible to receive capital outlay dollars from the state. You'd be considered a local unit of government, so you'd have a different relationship with other government entities. Right now, as a private association, you guys are considered just that. As a unit of government, you would be able to negotiate with, let's say, the county, the town of Taos, as well as the federal government. We've been working a lot with the U.S. Forest Service on some of their plan revisions. They recognize those land grant center units of government as being that government entity. They have sort of a different relationship in terms of how they interact with those entities. There are also some more reporting requirements in terms of transparency. You guys now, as a private association, I know you probably have to do your corporate reports on an annual basis. You have to file your income tax reports. You wouldn't do income tax reports anymore because as a unit of government, it's not the same type of reporting, but you would have financial reporting to the state of New Mexico depending on the incomes. If your annual income was less than $10,000, it always is a certification that you have less than $10,000 in revenue. If it's beyond that, if it's 50,000, between 10 and 50,000, you have to report to, just to do a budget that's submitted to the state local government division. And then if it's above 50,000, it goes into some different tiers where you have to do like, not a full-blown audit, but you have to do some agreed upon procedures where you have a CPA look at some of your books just to ensure that things are being done within the GATSB standards, the General Accounting Principles and Practices. It also sort of allows for more transparency in terms of the community. One thing though, since you guys are sort of a shareholding entity, you have to sort of figure out, well, what does that mean in terms of conversion for who are the heirs then of the community who have that, if you were to do that, and what would that look like? The good thing is because you have sort of, looking at the way it was sort of settled, it was based on the heirs who were sort of members at a certain time. I think it was in the 1940s. So that could sort of be the beginning base to say, okay, well, here's how individuals. What would go away though is the shares, in the sense that nobody would no longer be sort of an individual owner of a certain percentage of shares. It would really be community. Now, land grants in their bylaws though do have the ability to sort of determine how is that passed on. So we do have some land grants. ABQ still sort of like this. The San Antonio Las Huertas land grant down in Las Citas, where they had sort of a closed membership, and it was sort of tied to individuals who were heirs, and then it's like one. The membership passes on to one person per household. We do have other land grants that have opened that up, and it's just heirs, and you just have to sort of, whatever your criteria for how you make people apply to sort of be recognized as an heir, and then as long as they're in good standing, then sort of their family could potentially be an heir. The statute defines heir as an individual who is a descendant of the original grantees and has an interest in the common lands through inheritance, gift, or purchase. We're looking to potentially amend that to allow for individual land grants to sort of define heir within their bylaws, because that definition doesn't fit every single community just perfectly. So, and as I mentioned, there is an interim committee that's actually going to be meeting up here July, I believe it's going to be the 18th and the 19th, and they're going to be Arroyo Hondo Arriba Land Grant, as I understand, is going to be hosting that meeting, so it'll be there in Alberto Seco. That may be an opportunity for those of you who live here in the community to go actually attend one of those meetings and see exactly how that functions.
Is your land grant similar to ours?
Yeah, they're actually quite similar to yours. They're a land grant that was part of the Arroyo Hondo land grant, and under Mexico they were partitioned. But then when they received their patent from the United States recognized the entire original grant, not their partition. So they actually had to go to court and get recognized as a separate entity from the whole grant. And so they are recognized, and now they're considered also sort of a private entity because they're a partition of a larger grant. We passed some legislation last year that would have allowed for them to be recognized as a unit of government, but unfortunately, the governor didn't sign the legislation. So they're looking to reintroduce that again this year. And they are seeking sort of status as a political subdivision. One of the challenges that they've had as a community, not being a political subdivision, is adverse possession of the common lands and people sort of encroaching and trying to claim ownership. And so they have to then fight that as sort of private property owners against each other. One of the protections that the statutes provides for land grants that are units of government is that you can no longer have your lands adversely possessed, provided that the claim didn't vest before you were a unit of government. And so once you're a unit of government, there's nobody that has an adverse claim, and they meet all those, I think there's like 7 things you have to meet, like notoriously possess it, you have to pay taxes, you have to sort of like be in possession of it and let everybody know. If they hadn't done that for 10 years, at that point in time, if you guys were to become a unit of government, then they could no longer do that. And so you would never have, you wouldn't have any more threats to your lands in that regard for folks encroaching. And I don't know if that's an issue for you guys, I just know it's an issue for you guys as neighbors to the north. They have had that.
Huge.
Yeah, where they have people kind of move in and then they sort of put fences around certain things.
Is there a possibility of doing a hybrid with the?
It's possible in the sense that we do have land grants that have their own specific statutes. And so those land grants that were recognized in statute before, they have an option to sort of be recognized in a different way. It is possible that if this community were to say, we're interested in that and to go before the interim committee, they may be willing to entertain, well, let's create a statute that will be specific.
So keeping everything the same as a private organization that's being incorporated in a sense, in other words, as far as voting shares, voting rights, that kind of stuff.
Potentially, the one thing that the statutes do is they allow for a lot of leeway within the bylaws. The statutes basically say you're governed by the Treaty of Guadalupe Hidalgo, the state constitution, the statutes, and your bylaws. And so wherever there's no specific information in the statute, you can put stuff in your bylaws. So membership, how you determine who are qualified voting members, how you determine how you register new members, all that, the statutes allow you to do in your bylaws. So there is still flexibility within the determination of who can be an heir and how you do that. And so, again, the example I can give you of San Antonio Las Huertas, for years after the statute had changed, they still kept a very closed membership base. And now more recently, though, they've realized that through attrition, they've lost a lot of folks, and some of those memberships never passed on. And so they realized that we're not getting enough new folks involved. So they recently went through a process of opening up their membership, and they had like a short window where they said for the next 6 months, we're gonna allow for an open membership. And then it allowed individuals who, let's say there was only one individual within that household who was a member, they were able to then get their siblings, for example. Like if there was 1 out of 5 siblings that was only the member, some of those siblings, maybe 3 of them said, well, I'd like to be a member too, and then they sort of came in.
Yes.
And so they allowed for, Chile League did something very similar, and what they did is they actually did a sliding scale where they said, well, look, if you're gonna come in now as a member, and let's say we've had folks that have been members since they were 18 years old, and they've been paying their whole life into the grant or to providing work, and someone wants to come in now when they're 60, well, they have to pay a higher percentage to come in, like a upfront fee, in order to sort of make up for the fact that they haven't been providing sort of support for paying the taxes or doing work projects.
But the voting was all the same. If you're a member, you get 1 vote.
Yeah, it's one member, 1 vote. So like,
But that could change. I guess you can do a hybrid.
if you guys have like votes per share,
Right.
I'm not sure. That's a question that will probably take a little bit more legal analysis as to if you could continue to have that.
That
Now,
could be defined in the bylaws though, can't it?
Potentially. I can't say, I don't wanna say for sure. One thing that we could provide you guys through the council, if you guys were interested, in pursuing potentially becoming a unit of government, we do work with, New Mexico Legal Aid, to provide free legal advice and assistance to community land grants. Now, technically, the council's only supposed to provide assistance to those land grants that are units of government. However, they make an exception when it's the potential that someone's coming on to actually go through that process. There's some questions that need to be answered to determine if that's what you want to do. So I think that's something that would fit under this scenario. If you guys have those kind of specific questions, like what would this look like and is it possible? I can't say for sure because the statute doesn't really speak to that. Now, as I mentioned, there are two very distinct statutes that cover land grants as it relates to units of government and those that are corporations. And what's interesting is that even under the corporation laws, it really meant corporations as corporate bodies such as incorporated towns and communities. It really wasn't specific to like business corporations, but we did have some statutes that were created in the 50s for the Atrisco land grant that actually divided shares and did that kind of
So
stuff.
when it comes to that, elections like nepotism, they would fall under that, in either the private one or the corporation one or the government one, right?
So right now under the
Either one.
under the general provisions, there are some requirements that there is nothing that bars individual family member or family members from serving on the same board together, but there are some things that bar you from serving as like an election judge if your family member is running for office.
Everybody in this association is related one way or another, so it's
Yeah,
just,
so, and that's how a lot of community land grants are. So there really isn't anything in the statute that bars that. We have had some land grants that as individual in their bylaws have decided that they want to have a certain degree of separation in terms of degree of relationship. The most recent one was the Tierra Maria land grant because some of you may have heard of that embezzlement that happened there. Well, what happened is they had two brothers and a nephew that were on the board, and three of them were controlling the board. And so in order for them to sort of avoid that, they created now in their bylaws a separation of the degrees. So they said, well, you can only serve if you're like, I think it's a second degree or something. So that way you wouldn't have any two siblings on it. So that is something you could consider. You could even do that now, I guess, as an association without having to go through sort of changing your structure.
Why would that not be considered a conflict of interest if you are an officer and then become a member of the board and you have a certain amount of nepotism? Why would that not be conflict of interest?
I'm sorry, when you say an officer or a member of the board,
Well,
what do you mean by that?
in certain cases, let's say that an officer and a relative of the officer are members of the board. Would that constitute a conflict of interest?
Potentially, but again, it's gonna depend on how you're governed and whether it's in either your bylaws or whether it's in the statute. And so right now, there is nothing in the land grant statutes that bars siblings, married couples. There's nothing that bars that. But we do have some land grants that have taken it on in their bylaws to say, we do not want this. And because the statutes allow you to govern yourself by your bylaws, you can actually create those type of separations, and then they're valid because the law gives you the authority to do that.
Getting back to, you said the board could allow more members in, but if you have an original list, and you have X amount of shares, then you have to have approval of all the people in those shares to let people in, because in theory, you're devaluing the price of that share that existing members own, correct?
Yes. So if you guys were to opt to do this, and we've had the same conversation with Hakona, it's very similar to you guys where they sort of have shares. It would be up to those individuals who are currently shareholders to decide to
But
vote.
you'd have to get all of them first.
Yeah, you'd have to get like a majority of them to do something. So anything that you guys would consider to do, it would have to go to a vote of the current legal entity. And so that's really the point of me being here today is just to provide you guys information so that you guys could sort of think about it. If you guys needed more information, I'd be happy to come back, and just for you guys to be able to make an informed decision or determine if this is even something you want to do, because it may not be. But if so, I just want you to know there is help through the council we can provide to sort of support you through that process.
Arturo, so, how do all the other land grants identify who those true members or shareholders are? I mean,
So what happens is that, because of the way it's sort of defined by statute, in most land grants sort of have a historic list, right? Because you know who you are, you know who family folks are. And so a lot of times, if they're trying to like create a new list or determine who's eligible, some of them will do genealogies. Because you guys, if your origins start like in the 1940s when we created the association and you're sort of saying this is our list of our membership, and everybody who's gonna be a member thereafter has to somehow be related to those original heirs, then it's a little bit easier because you're not going all the way back to like the original grant. And I don't remember the history of the Antonio Martinez if that was I know some of the grants here go back to the 1700s.
And what type of relation do you need to have? Is it like father, son, or cousin, fifth cousin, sixth cousin?
So right now, the statute just says that you're a descendant of the original, so if you were gonna say, well, the originals were these folks in the 1940s, because that's the list we're gonna start with, then they would just have to sort of be legal descendants of. And a legal descendant would typically be, you know, sons, daughters, could even potentially be adopted. We do have, because if they're legally adopted, they become sort of an inheritor.
Arturo, what protocol did they use to be able to identify that lineage from the original members?
For you guys specifically?
No.
Or just in general?
In general.
In general, what we've had communities do is they'll actually start their genealogical research. We did sort of a big project with the San Miguel and Motherland Grant, and they actually went through and identified, they started looking at the families and just going back, using different tools like Ancestry.com or using, I think San Miguel del Valle, they actually bought books. The council was able to provide them with some money to purchase genealogical books and records from the local churches and the archdiocese, and there was some books that had been compiled, so they were able to actually look at those. And then it's still up to some individuals to say, okay, well, we have a list of who we know are heirs, now you gotta tie yourself to them. And so they actually had like genealogical forms that you could fill out and show, like, this is my parents, and these are my parents' parents, and then they tie back to somebody on that original list, and then the committee would actually review that and say, yeah, these are valid connections, they are in fact heirs.
That would be an individual responsibility then.
Well,
Some of it's individual, some of it is on the group.
So, and I guess we have a situation where there's been memberships purchased that don't come directly from a lineage, but they are heirs from another lineage, but are not a member, but could be, but unfortunately the deed was not to them, so they were able to purchase,
They purchased it.
some. So that's.
So,
kind of a
and we do
dilemma.
have that in some other land grants, the Truchas land grant, they actually have a very similar situation where they're considered private, they have their own statute. And that's one of the reasons why they have not opted to become a unit government, because they have some individuals that have purchased and they don't want to disenfranchise them. And that's one reason that why we're advocating, not just the council, but sort of some of the land grant leaders of the state, to actually try to make a change to the statute so that the definition allows the land grants themselves to define what heirs are. Because you may have some of those situations that, let's face it, the state came down on land grants very hard in the early days and started taxing them. And sometimes in order for those communities to survive, people who were original heirs actually helped bear the burden of the taxes, and they're sort of became members.
But again, the land grant, the bylaws could identify what's allowable and what's not allowable.
Yeah, so technically, the way that the law defines it now is it's a very narrow definition, but we do have land grants that have the same situation, and they define it in their bylaws, and they operate, and they haven't been challenged in court to say you're doing it wrong. Placitas, Salto and Huertas is very similar. They had the same situation where in the 30s people bought in to help pay the taxes, and they then became members even though they weren't initially. Now keep in mind, under Spanish law, the way that it worked is you actually didn't necessarily have to be one of the first families to get granted land, and sometimes those families even left. It was the people who actually stayed in the community and actually became part of the community that were entitled to sort of, as long as you were a good standing member of the community, you were able to sort of access those common lands. So there is sort of a logic behind that, and there's a history behind it.
How does precedent apply to this whole thing, as far as the law is concerned?
Precedents for what?
In other words, when these last land grants were given by the original owners and it goes down to the descendants, is that the precedent that they apply?
Again, it's going to be on a case-by-case basis, so it really depends on each situation. Is going to be sort of unique, and then it's going to depend also on how you guys see how they pass the memberships on. Is it something that's official? Is it something that you guys as a group have to approve? I'm not sure how you guys do that as an entity.
So you're saying the bylaw should be defined on how this should be taken care of then?
Yeah, your bylaws really should. I mean, if all you have is sort of what you have in terms of your incorporation papers, what I saw, like that's pretty weak in terms of actually defining how.
All it has is a name, Padamon's name, and really no direction on why
Yeah,
we
and
even.
so-
We didn't really have no direction on how we became a corporation. So I haven't even seen any minutes to even get to that point to say, well, we should be a corporation. So
So those are all things that, regardless of whether you guys were to become a government entity, I would say you'd want to take a look at how do you structure bylaws that are going to spell out how the organization is managed. Just because that's what helps you when there is doubt. You just go back and say, well, how do we actually, what are the procedures for allowing memberships? What are the procedures for recognizing members? What are the procedures for recognizing shareholders? And so if all you have is what was filed and it's only like a 3 or 5 page document, there probably is some room for you guys to improve that process.
'Cause from those 67 original members, it jumped up to 50,000 shares. So all that did was confuse it even more to where nobody really knows what's going on right now. So, you know, we have 2 separate meetings. We have this one going on and we have the other meeting going on right now. So it's just, we'd like to get to the bottom of it.
I guess the question for you is, we have a situation where our board was hijacked by nepotism to close, and that's probably because our bylaws were kind of weak maybe, or we just didn't foresee what could happen. I think some of us did, but the membership at large didn't really, and it happened. And so now we're in a situation where we have, another meeting going right now at a different time, and they just sit firm that they are the board. And so has other organizations or other.
That's happened with other land grants where we've had 2 boards at the same time.
And what has that?
And unfortunately, the only sort of recourse is, it has to go to court action where they've actually been able to go and say, okay, well, the court needs to now recognize that, who is the true entity and correct. And if, part of the problem is if you guys don't have good procedures for how you, and your bylaws are silent on that, then it might take sort of a reset. And we've had that happen in the case with Tierra Maria where they had the embezzlement. It took the community coming forward and saying, look, we don't agree with what happened. And so the council stepped in and provided assistance with that steering committee to put together some bylaws and actually provided legal support to go to the court. And then the court, the first judicial district court came in and said, okay, we're gonna put that other board aside. And that board chose not to fight it. And we're gonna hold a new election sanctioned by the court. And then the court election actually appointed new officers and sort of.
So in the case that we are facing a situation where the board that was hijacked has illegally, I guess, without the permission of the members, has spent money, has done illegal transactions, how would the court view the 2 boards at that point then?
It's gonna all be based on what my thoughts are. It's gonna be based, without knowing enough, on sort of the legal opinion of the court, right? You guys are one side is gonna make a claim and say they did not have the authority to do this, and if the court finds that they in fact did not have the authority, then those individuals could potentially be on the hook for what was done. But again, it's all gonna depend on who's the attorneys, and what makes it difficult, and we've had this happen with other grants where they've been fighting this, becomes a question of, well, do the organization's resources go to paying legal fees?
Right.
And whose legal fees do they pay? And so, you know, that's happened in grants, and we've had in San Miguel del Vado most recently, they went through 4 years where they were having a battle over like who was the legitimate board.
What did it cost them?
For the individuals as private that were sort of fighting it, I think it cost about roughly 20-some thousand, and I assume on the other side about the same. But one side was using some of the board money, and now the new board that came in said they actually don't think had the authority to do that. So now there's going to be some question as to were those individuals, are they going to have to pay that back as individuals because they shouldn't have actually been using, because the court was actually recognizing the parties as individuals, not it wasn't an official court action against that board. Now with you guys, if you guys are taking action against two potential boards, then it becomes a question, and it's obviously a civil matter because you guys are still considered a private entity. And you guys would.
How does equity, let's say a lot of the members have more equity than the people of the board. Some of them have really diluted equity. So how does that,
Well, you know, based on what I saw of your guys's, the way you were incorporated is it sort of said, here's a finite number of shares, the 50,000 shares which you kind of talked about. And then it just sort of said all the people that were heirs of these people from 1942. But it really doesn't define, like, and it's, I think there's some language in it that says you can hold, one individual can hold more than one share. And then it would become a question of probably going back and looking to say, well, who actually has
But you can
how
also
many shares?
vote by shares.
Well, and it depends. Again, it doesn't really say that in your guys' incorporation papers.
Well, you would think that if there's 50,000 shares, that would be divided amongst the 75 original members.
You would think that.
But
There's nothing clear there. It doesn't really say. It doesn't say like everybody started with one share and then the rest are meant to be got by heirs. It's really not clear, and that's where it gets kind of ugly. This happened with the Atrisco land grant, where they had shares and then they started dividing into like Class B stock and Class A stock, and So when that community, I don't know if you guys remember several years ago, they sold to SunCal, and they sold like, they had about 50,000 acres that they sold to a development in California. And that thing came down to the same kind of a fight where it was shareholders who had a little bit of shares versus a board who had amassed thousands upon thousands of shares. And so a very small group of individuals were able to sell and come out making millions of dollars, and the rest of the community was left.
That's kind of like where we're involved right now. So, like how you said, a lot of shares have been watered down. With whatever has been watered down, there's been a few members that have really picked up the rest of the shares. From 7 to 3 to 5, and even members from last year. There's some that they've already recorded even going into last year. Just.
One of the things that we could potentially do to at least shed some light on the subject would be to potentially bring this up before the interim committee. Like I said, they will probably be here in July. If there's folks that are interested, you could go. There's a public comment period. They're gonna actually be meeting on Monday in Salto to do their organizational meeting and determine what they're gonna talk about. I'd be happy to bring this up as an issue, that there's just a concern if there's a community that's it has its roots as a land grant, but they're actually sort of a private entity now, and they're having sort of internal. They may be willing to entertain at least listening to what you guys can do. Keep in mind, as a government entity or as a legislative body, they can only provide legislative fixes. And my sense from having been doing this for the past 13 years is that the interim committee really leans strongly towards the unit of government, so they may say, well, we would encourage you guys to sort of go this path because then there's more protections for you. But again, it's something that every community has to decide for themselves how they want to be recognized.
So we're also in another situation where the financial aspect of the association is at risk. So our president wrote a letter to the bank denied saying that he's not the president, only because, like I said, the board was hijacked by other individuals, and they feel that they're against him, but the members here are still saying that he's the president, he should be in charge. So what happens at that point, or what?
So part of what's gonna have to probably be done is some legal research as to where you guys are as an entity. I don't know if there's been anything else filed with the Secretary of State's office.
Well, right now we're in a declaratory judgment, so we're waiting for the judgment to actually say whether we own shares or if it's the heirs or if it's people that have bought or so that's what we're kind of waiting for. So.
Yeah.
And actually, we wanted to get a little bit more clarification, see where we're at. So it's just.
And that is going to sort of help inform where you guys are, because I imagine that there's probably. I know if I was trying to sort of work my way around becoming a legitimate board or body, I would be, to the extent possible, using the law on my side. So whether that's filing paperwork with the Secretary of State saying that I'm the officer, and what happens once those things start becoming filed, they set the legal precedence as to like who's actually where. And then that's what you have to sort of be able to.
So as a member, I want to protect my interest, which is the finances of this organization. That other board is spending my money without my permission, as they see fit.
What money are they spent, Joe?
Well, what I've seen, and these are just the emails that have been going out, but I've seen some documents that say we had 118,000 last year at this time. We're down to 81,000. They've hired another attorney that I didn't know that they were going to hire to educate them.
They mentioned it in one of the meetings, so it just.
But we don't vote on it, and that's the question. We, as members.
We've got more legal information from these attorneys in 1 month than what we have out of Cutter McCarthy.
That's understandable, but the question.
It's not understandable. We've had Cutter McCarthy as our lawyers for so many years, and they haven't done nothing for us.
The point is that the organization, the membership, did not give them the permission to do that. That's all. Whether the information that they're providing is good or not.
They got 3 out of 5 votes there. If Palemon and Romero weren't there, that day they should have been there to at least fight for it. I haven't seen no finances being drained from this association. Just we waited this long to actually get information. In the last 6-9 months, we've got more information than we ever had. Everything was buried for so long in somebody's safe or something.
So it's not about the information. It's not about anybody's hiding anything. It's about the process of how it's done. That's what's concerning us, and that's why we're here to talk about the process.
The process was basically the board and the vice president.
So part of what I would suggest you do
We were left out of the loop.
is you actually go back and someone needs to do that legal research to determine, are there bylaws or is there any other articles of incorporation or anything else that sort of points to how you're supposed to be governed. Because in the absence of that, then folks are just sort of making up where to go. And if that does exist, then that gives you at least an ability to say, well, wait a minute, these weren't followed. And that would sort of be the leg you stand on if this were to go to court, is to say, wait a minute, they didn't have
So would
authority.
we file that as an individual, or do we file that as a current board, or how
You
is
could,
that filed?
I mean, it could be individual heirs that are concerned, it could be you guys as a group to say, we're gonna challenge the authority or ability of this. But I would recommend first you do your legal research, right, you get your board together, you figure out, well, do we have a case, or is there something we can do? We may be able to provide you guys with some assistance, again, it depends on what path you guys wanna take, right, because, we have in New Mexico something called the anti-donation clause. It's part of our state constitution. What it basically says is that no state dollars can be spent for private interests. And because you guys are considered a private corporation right now, it would be a violation of that. If you guys were sort of doing it with the intent to becoming a government, then there may actually be a way for us to do some support. But it's a very gray area, and we couldn't commit to anything here. And I don't even have that authority anyway. I also have to report to our council that's appointed by the governor. And that 5-member council then votes and decides what they're gonna do in terms of support to communities.
In order to
I
become
think
a
you
new
had a
government,
question real quick, sorry. and then I'll- Go ahead.
in order to become a new government, how does the issue of quiet title fall into that in regards to the state?
In what do you mean?
Well, in order, that's what started this whole issue, is we're trying to get quiet title on the property itself. And in order to become a government, does it require that the association have quiet title to the property, or?
And that's been established, the quiet title should have been adjudicated. What we're trying to establish what is a membership, the people that, and actually what we're doing, Arturo, there was, what McCarthy, the attorney for the corporation, did, they were initially, it fluctuates back and forth. They had 66 original members supposedly, and then the 50,000 shares divided by that would give them, I think it would give each individual 650 shares per. Now if it's 75 and you divide that with the 50, then that would give 757. So there is that division, that divide between the 66 or that's what the special master is gonna actually decide on.
So you actually do have a pending court case with the special master appointed?
Yes, yeah, and the thing is that takes place October the 23rd. The problem is that we're trying to eliminate as much, we don't wanna go into bankruptcy. And we don't wanna have anybody else, criminally charged. I'm gonna meet with the DA's office on Monday. He's gonna give us some, and then I'm gonna show him everything that's in here, what's been done. And then if we have to go to the next level of, to address it civilly, then we'll have to obviously do that. It's unfortunate, but it's come to that degree.
Well, if there's already a sort of a pending court case, then probably what has to happen is you guys would have to resolve that first before you even sort of take the next step to decide what you want to do. Because there's already a jurisdiction that's overseeing that, right, through the court.
But couldn't you put an injunction on the checking account, something like that, to stop spending until this is settled?
You could go, if there's already sort of a pending case, you could make some, I don't know who the parties are to the case, you could make put a motion before the judge and ask them